All right, our last case on our docket this morning is 18-A21, ONICA GRAZETTE versus, apologize if I'm mispronouncing that, versus Magical Cruise Company Limited, DBA Disney Cruise Line. Counsel, whenever you're ready, go ahead.
May it please the court, Paul Feltman on behalf of Ms. Grazette, and I'm here with Alex Gonzalez, who was trial counsel. This case is fact-intensive, and I'd like to just, if you allow me, to go through the first 2 months of what occurred. In December of 2011, Ms. Grazette heard a pop in her back, and at the time she gave her deposition. She testified, "What caused your back to pop? I don't know. Do you know something was out of the ordinary when you heard the pop? No, sir. Did you go to the medical center? No, sir. The pain stopped immediately. It's just as fast as the pain shot through. I just sat down and stopped. You mentioned you said just as quick as it started, it stopped. And when it stopped, then you were completely free of pain. Yes. So you continue working? Yes, sir. Did you take a break? No, sir. After, as I said, as I felt pain, I sat down and then I got up and continued working. How long were you sitting down? I don't remember. Did you finish up? Did you finish your shift that night? Yes, sir. Subsequent to that, on December 29, 2011, she presents to the ship's doctor, who does not do an exam, but on the next day disembarks her on January 1st for some palliative care shoreside. Between January and February, she undergoes some injections. She has massages, laser treatment, again, palliative care. Now, on the 10th of February 2012, she is declared fit for duty by the shoreside doctor, Dr. Barrios. Dr. Barrios writes to Mr. Heinmiller, whose some testimony is in our brief. He's the Marine Claims Representative for Risk Management Department at Disney Cruise Lines. And he says to him, impertinent part of this letter, on 16 January 2012, she did x-rays which showed very mild scoliosis.
Let me ask you, I mean, obviously the statute of limitations is the big issue.
Right.
It is the issue. All right, so your complaint says that this all happened on the Wonder, the ship, the Wonder. That's what it says.
Well,
She said she went on there too. I mean,
that's
really not clear.
It doesn't
I mean, I know what the record says, but it says the Wonder. So they say, well, she didn't work on the, it'd been over 3 years since she was ever on the Wonder before this 2015.
Right, and that's why I'd like to explain what the facts are, because there was never a date that was given certain as to when they claimed the injury was in December 2011. She had two further contracts.
I mean, at the outset, I guess when they answered, you had a pretty good clue what their defense, what they were going to defend on the statute of limitation.
Correct.
Something did happen on the 11th. I mean, I read the record, so I know what you're saying.
Okay.
But here's the rub. I mean, in my sense, so anyway, you kind of got the idea where they're coming from.
I'm stuck with the default.
Huh?
I'm stuck with the default. So,
but so you got to you know where they're coming from.
Exactly.
And your theory is, well, hey, she fell out of her bunk, and she's got a herniated disc. This is 2015. I mean, there's all kinds of things. She was a frequent flyer to the med center, but a lot of times had nothing to do with pain or in her back or her neck. But still, the pleading was an issue. Then you file a motion to amend the complaint, right?
correct, trial counsel did.
There's a summary judgment. They file for summary judgment.
Right.
You file a motion to amend the complaint. Your second amended complaint picks all that up. You say it's a fantasy. You got the 2015. And I mean, it's clear from the record she was on, I think 4 ships, over the period of 4 years.
Correct.
All right. So the motion to amend the complaint never gets called up, right?
Correct. But I think that, if I may, Your Honor, I don't want to speak over you.
I'm getting ahead of you, but I mean.
I know exactly where you're coming from.
I'm trying to figure out what, and I read, the summary judgment hearing, no one even mentions that.
Well, I'm going to talk about the first complaint because I think it was vague, but I do want to just complete what I was about to finish with regard to this first disembarkation, and then we'll come back to the pleadings.
I think your argument is, look, Judge, the statute of limitations is a fact issue in this case.
That's correct.
It's for a jury to decide, not a judge as a matter of law.
Correct.
All right.
And the point is, when she was declared fit for duty after the palliative care on February 10th, 2012, they inform the cruise line On 16 January 2012, she did x-rays which showed very mild scoliosis in her spine, and the report's attached. No abnormality has been demonstrated. They took an x-ray and they didn't see anything wrong with her spine. And then they went on the second page, Dr. Barrios tells Mr. Heimmuller of the cruise line, he's the representative who's going to bring her back as fit for duty, back and spine, lower back muscle spasm, and tenderness in the coccyx area, in her rump. And then he says,
I spent a lot of time reading those records in your briefs, and I understand all the medical pretty well. I'm concerned about the way the pleadings were. And
Okay. Okay, with regard to the pleading, let me just finish this last statement.
Okay.
And then, no signs or symptoms of nerve compression. So there's nothing there at the time.
I'm with you.
I think that the pleading was inartfully drawn. I think it was vague. I don't think it necessarily
You may be right.
locked
What I'm
them
trying
in.
to say is you obviously, someone figured out, look, we got a problem, we need to amend the complaint. We need to say, because it was apparent from like your discovery, what their defense was, so the Second Amendment complaint gets the right ship, it gets the right date about things happening, although the dates, I'll give you the dates in the first complaint. But here's my question. So you go to the summary judgment hearing, the real issue is, is there no disputed fact about the statute of limitations? And, and one of the arguments, I think, that Disney made was, look, Judge, they said it was on the Wonder. She had been on the Wonder since, for over 3 years before they filed this suit.
Correct, Your Honor, but I think it's very clear.
All right, but you're sitting there with, you're sitting there with an amended complaint and a motion to amend it, and no one even calls it up or even tells the judge about it.
Regardless of the amended complaint, Your Honor, I believe that the trial court considered all of the evidence that occurred over that period of time. And if she did do that, which she did do, then it was very clear that regardless of an inartfully drawn complaint, that they kept declaring her fit for duty, the doctors kept telling her she was okay, and they kept sending her back to work. And this report from February, right after the initial incident, shows that they took an x-ray, there was nothing there. And so the judge considered.
I'm with you on the medical stuff. I understand that. To me, it's clearly a fact issue. It really is. But what worried me is, is the way the complaint's drafted. And then, do me a favor on this. One, did anyone for the plaintiff ever bring it to the attention of the trial judge that there was a motion to amend a complaint out there?
May I ask trial counsel?
You weren't trial counsel, were you?
No, I was not.
No.
He was.
Oh, okay. All right.
Just one moment,
All
excuse
right.
me.
You can ask him, yeah.
All right. What I've been explained is that there was, on the last motion for discovery, there was a request that they be allowed to amend. It was brought to the attention of the trial court, and then suggested that there be the amendment, and then the amendment was made, but it was not heard, obviously. I'm not disputing that.
The motion was there. There's never notice for hearing, and I read, the transcript very carefully of the summary judgment hearing. No one ever mentioned it.
I understand, but in the context of what's going on in this case, I think you understand that when this occurred would be a question of fact. Clearly, it is.
Let me follow up. Are you saying that if there was no motion to amend ever filed, that summary judgment was still inappropriate here under the statute of limitations?
Yes, I am, Your Honor.
Based upon the pleading, the operative complaint that was pending at the time?
Yes, and because the trial judge clearly considered every single incident in making the decision to enter the summary judgment. So the trial judge looked beyond the complaint, not just focusing on that and saying, listen, this is your complaint. You've pigeonholed yourself here. The trial judge said, you know what? I'm going to look at everything. I think this is a really harsh result. maybe I'm
Especially
going
she
to...
was troubled. I mean, I read that.
Yeah, and I don't think it was because she didn't do that because she was concerned about the complaint. She looked at everything and she agreed with the cruise line that this incident...
The cruise line made the argument, because I was concerned about this. The cruise line made the argument, Judge, they said it happened on the Wonder. She hadn't been on the Wonder for more than 3.5 years, before the complaint was filed. It doesn't matter, any of this stuff doesn't matter. It's outside the statute of limitations. I'm not so sure she didn't buy into that. That's what they argued. That's exactly what they argued.
Going off that, that's my fundamental question as well, is if the issue wasn't properly preserved as to the amended complaint, and the reliance was on the original complaint, which said nothing but the Wonder, then why wouldn't summary judgment be appropriate?
If you can rephrase that for me, please, Your Honor.
Sure. If the original complaint says that everything happened on the Wonder, which would be outside the statute of limitations, correct?
Correct.
And the amended complaint has not been properly, the issue about the amended complaint has not been properly preserved for appeal, so that goes to the side, then why wouldn't summary judgment be appropriate, because all the allegations are that everything occurred on a boat that she hasn't been on in a time period that's longer than the statute of limitations. I mean, I know that's a simplistic summary, but that's...
I understand, and I understand what the operative pleading was, but what my argument is with regard to that has been raised is that it's very clear that the judge considered the other times, the other ships she worked on, the other injuries, but related it back to the representation of...
But she said I got hurt. She got hurt on the Wonder. Now, whether she had other ailments along the way, I mean, let's make it a little clear. Let's say that the allegations in the complaint, I had my back popped when I was doing something on the Wonder on November 1, 2011. I then, I continued on, I worked, I had problems, and the suit wasn't filed till 2015. Why, as a trial judge, couldn't the trial judge say, okay, reading what you said, plaintiff, it appears your cause of action accrued on that day, and you filed 3+ years later, so you're barred under the statute.
Because I go back to that being inartfully drawn, and this is very important, because they're trying to say that the client, Ms. Grazette, could have filed suit at that time. And this letter from Dr. Barrios proves that there's no way that the suit could have been filed.
I'm with you on the medical. I mean, I think there's a fact issue. I mean, she worked, they released her, she's vacuuming, it goes out, she went to the doctor like 7 times, 5 were unrelated to anything. I mean, clear, and then she did have an event in 2015 when she fell out of bed.
Right, she fell out of
the bed. Radiating pain, and she got a MRI, doing an MRI, a herniated disc. I mean, I think it could be the 11, it could be the 15, but I think that's a jury question. The question, though, my trouble is, you said in the complaint, it happened on the Wonder. My injuries happened on the Wonder. So they say, in the arguments to judge, they said it's happened on the Wonder. It's in their pleading. That's their pleading. Taken as true. She wasn't on the Wonder, more than 3.5. I mean, it was like 2013 or something. She wasn't ever on it again. She was on other boats, but not that one.
Right.
So that's the inartful part of it. And obviously, someone thought that too, because you filed a motion to amend the complaint, and you put the fantasy, and you made it right, basically. But I mean, that's what my trouble is. I mean, they made that argument. I'm not so, and she's struggling with it. You're quite right about that too. Like, this is a harsh penalty. But she may well have believed or felt that was the case. You said it was on the Wonder, and you're out the window.
Well, I understand that, but at the same time, the complaint does talk about the other incidents that occurred. And
it doesn't say where or what ship. Don't you have to say where it happened? Or, I mean, don't you have to say, or just...
Well, I think that the essence of what
I'm not
the
a
argument...
admiralty lawyer, but it seemed like
the essence of what... I'm sorry for speaking over you.
Are you saying that she had other incidents after 2011 that were negligently caused by the Disney, or?
But what she had was every time she went and presented to the doctor, she had mechanical back pain or ligament sprain. That's what they told her it was. They gave her some naproxen, some Tylenol, something palliative care, sent her back and rest. The next time where she was injured was she fell off the bunk bed onto her back.
In 2015?
In November of 2014, and then the MRI is January 17th, 2015.
And then that's when it's okay, don't work anymore.
But that's when they tell her you can't work anymore. But what they're trying to say is no, the injury occurred back at the when the back popped, and it's not really that she worked on the Wonder. They're saying the event itself, not just that it was on the Wonder, but this one event itself is evidence that that's when it happened.
I understand.
That's when
I'm
they're
with you
saying
on all that. I'm with you on it.
I appreciate that, because that's when they're saying it accrued, and it could not have accrued based upon the medical evidence that it was just ligament sprain, back spasm, mechanical back pain. That could not have been. Their argument is not solely this issue of the Wonder. It's that pop should have put her on notice, and in spite of Dr. Barrios' letter and them not finding anything with an x-ray, she should have sued.
But I mean, okay, so I'm in a car accident, I have a whiplash, and I go and there's nothing that shows up demonstrably on X-ray or MRI. My cause of action accrued on the day of the accident, and if I have continuing pain and I go see the doctor for things over the next 4 years under the state statute of limitations, and I file suit on the, 3 years, 11 months, I'm still good. Or if I file 4 years and 1 month after the car accident, then I'm out, aren't I? Even though I've seen doctors along the way?
Well, because of the nature of what kind of care they have to provide, and I did do a notice of supplemental authority, and it's very important, the standard of care that they're supposed to be giving to these crew members. And I filed with the court. It's a fourth DCA case, but it follows, the Supreme Court precedents, and it was the Van Mill case. And here, it's crucial what they say. Despite all of the evidence suggesting that Van Mill declined the captain's offers of assistance, ignored doctor's orders, and contributed to her injury, the law places a greater obligation on the captain to provide for crew members' welfare than it does on the crew members themselves. They have a heightened standard to take care of their crew members. And so if she thought it was the Wonder, the captain or whoever was in charge of that, Mr. Heimiller, the claims representative, should have been. He said he did no investigations at all until that time that she fell out of the bunk bed.
So if the act occurred on the Wonder, and we go with your original complaint, the only way that you come forward is through the discovery rule, correct?
Yes, I mean, they didn't.
And that's when you go into an analysis and you rely on the Pretis case?
Yes.
So my question for you is that if we go with that discovery rule, when you get to Pretis is a 3-part test, I believe. But I don't know of any other circuit or any other case that's applied that. If we take that position, are you asking us to expand the law to create a new test, or?
No, I think what Pretis did, if I may, Your Honor,
Yes, sir.
was to take different ways that these cases are analyzed. And they summed them up and they cited their own Fifth Circuit cases. Now, the dissent didn't agree with that, but that it doesn't take away from, and especially in a case like this, the simple facts that there was no way that she could have filed suit in 2011 or 12 or any time before the MRI when she was diagnosed, which is the only time she would have known or could have known. And that is the test.
So would you agree that the focus would be primarily on whether the injury was obvious or latent, and then in a latent case, then the plaintiff should have known the cause with the exercise of due diligence? Is that the test?
Well, if it's exercising due diligence, she's going to the doctor, and there's a doctor sending her back to work. You're fit for work. You're fit for duty. She has to be able to lift 50 pounds. She's got to open watertight doors. She's got to do the luggage, embarkation, de-embarkation, and she has to be able to get the crew members, the passengers off the ship in the event of a
You're
emergency.
running out of time on your rebuttal. You see the clock there.
Yes.
In other words, you're not going to have any rebuttal time left, so however you want to use your time.
Do I have any rebuttals?
That's what that clock is.
Yes, I know. That's what I said. I'm stuck with 15.
54 seconds left of your argument.
Total?
Total, yeah.
Okay, I want to get to the maintenance and cure. I just want to say the maintenance and cure accrues when there is inadequate, when the crew member is incapacitated to do seamen's work. There's clear here that that happened when she fell off her bunk bed, that maintenance and cure claim should never have been dismissed, and maintenance and cure is designed to provide a seaman with food and lodging when he becomes sick or injured in the ship's service and extends during the period when he's incapacitated to do his seamen's work and continues until he reaches maximum medical recovery. They've been continuing to give maintenance and cure. My concern is that if they're successful in this appeal, that's going to end. But clearly, the time for that to accrue was when it was incapacitated. And with regard to that claim, it definitely was filed timely. And I would ask that the court reverse the trial court and remand for further proceedings.
All right.
Thank you.
Thank you.
1 second or rebuttal.
May it please the court. My name is Cassandra Taylor. I'm here on behalf of the Appellee Magical Cruise Company Limited, DBA Disney Cruise Line. I may refer to them throughout my argument as DCL, or Disney Cruise Line.
Just call it Disney.
Or Disney.
There you go.
All right. Opposing counsel. As the court noted during my colleague's presentation, the critical issue in this case is the accrual of Ms. Grazette's cause of action. It's undisputed that the 3-year statute of limitation applies to Jones Act and seaworthiness, and I believe it seems to be undisputed that the 3-year statute of limitation also applies for maintenance and cure claims. I'm going to start where my colleague left off by addressing maintenance and cure, just to give a little bit of very brief background. I know that the court knows all of this, but I find that sometimes it's helpful to kind of go over the basics. Maintenance and cure is similar to workers' compensation, and it demands that a ship owner provide a crew member with maintenance, which is a daily stipend, and cure, which is payment for medical expenses. There are 2 different kinds of causes of action that a crew member may bring, or several kinds of causes of action a crew member may bring under maintenance and cure. One is an action simply for maintenance and cure, and that is for reimbursement of actually paid expenses to obtain medical treatment. Example, I went to the doctor, I paid the bill, ship owner paid me back what I paid the doctor. Or in kind, or reimbursement of their maintenance, which would be living expenses if they can establish that. Those are the only damages that are available under maintenance and cure. Just a simple demand for maintenance and cure. Now, where there is an allegation that there has been a negligent failure to provide maintenance and cure that has resulted in an aggravation of an injury, which is exactly what we see here in plaintiff's complaint, in those cases, the plaintiff may bring an action under a negligence theory for maintenance and cure. It's a negligence-based theory, and incumbent upon that, instead of being limited simply to reimbursement of medical expenses and reimbursement of medical expenses and living expenses, the crew member may also seek in those negligence actions compensatory damages that would be traditionally available under tort personal injury cases.
Let me ask you, do you agree with the statement that the cause of action for maintenance and cure accrues when the worker becomes incapacitated to do a seaman's work?
Absolutely not, Your Honor.
That's not, I thought U.S. Supreme Court said that.
So I believe the case of the plaintiff that Ms. Appellant, that Ms. Grazette is relying upon for that prospect is the Cooper case, and that came out of the Fifth Circuit. Now, the Cooper case, that falls into the first category, maintenance and cure, that I was just talking about. The first category, maintenance and cure, give me my reimbursement, no tort damages. Those cases accrue when a crew member may be incapacitated to work. However, when it is the breadth of the negligence cause of action, when it's what is claimed here by Ms. Grazette in paragraph 10 of her complaint, defendant's failure to provide me maintenance and cure aggravated my condition. And she goes on in count 3 to claim compensatory damages. You guys have to give me, because of your negligent aggravation of my injury, you have caused harm to me and you owe me compensatory damages, pain and suffering, et cetera. What she does not claim in that count are reimbursement of my medical expenses, nor does she claim reimbursement of any expenses for living expenses, which is what she would have under a traditional maintenance and cure. Now, under the just 2-part maintenance and cure, that's governed by latches, the equitable doctrine of latches. And Cooper talks about latches, and that's how we know the Fifth Circuit is thinking about the 2-part non-negligent maintenance and
Let me
cure.
ask you this. You agree there was an incident on the Fantasy in November of 2014 where
I-
she fell out of the bunk?
Yes, certainly. Ms.
injured
Grisette
her
alleged
back?
that she, I'm
That was
sorry?
an injured her back?
That's her allegations, but what she said was that she aggravated her
Disney
back.
Cruise Line investigated that one, didn't they?
She had an MRI in January. Wouldn't that be the time that she became incapacitated?
She had a bulging herniated disc at L5-S1?
Well, correct, but before that even happened, back in December 2011, she was incapacitated. Remember, we have at the record at 484, I'm sorry?
She went off the ship though, right?
She went off the ship. So the day of the accident, the very first accident, the luggage falls on Miss Grisette. She hears a pop.
But
She
my
hears.
question was this, there was an incident in 2014, November, when she fell out of the bunk. Disney investigated the accident, correct? They did.
There was an MRI performed in January 2015.
I'm saying an incident happened.
I don't dispute that Miss
She fell
Grisette
out of a
says.
bunk,
Just-
right?
just-
And hurt her back.
Just take a
Yes.
route, answer questions, and don't.
Forgive
try-
me.
yeah, Just answer the
I'm
question.
sorry,
No, no. just-
Forgive me.
it's not that hot a bench.
I don't dispute that Miss Grisette says that she fell out of the bed in 2010 and hurt her back and foot, correct?
And that Disney investigated in 2014 in November, right?
Well, after that, Ms. Grisette, as she had done before, went to the medical center. She got medical care and treatment, and she continued working. She worked from November 8, 2014 until January 20th, 2015. And it wasn't until January that she was incapacitated or taken off work to go home. She had this MRI on the 15th of January. So although she has this bunk bed accident in November, there's nearly 2 months or so before she's sent home. But this comes back to the prior critical issue, which is that in December 2011, the luggage falls on her. She hears a pop. She has a
Ask you
pain.
this, did you all argue at the summary judgment hearing, Judge, they said it happened on the Wonder. She hadn't been on the Wonder in 3.5 or 4 years. So it doesn't matter whatever happened after that, they're outside the statute of limitations.
Oh, certainly, absolutely. And in addition to that, we also argued, and not only did she have this
Now,
December incident.
Also, at the time, from discovery, Disney certainly knew where she was working, right? She worked on 4 different ships,
Correct.
right? She had issues on all of them. She would go, she was a frequent flyer to the doctor. One time I think she went 7 times within the period. 5 were unrelated to her neck and back. She didn't even make complaints about her neck and back. Then 2 would be, yeah, my neck and back hurt. So, she had these complaints right along. And then November 2014, she falls out of the bunk, hits her back, is what she says. Then she starts getting radicular pain and ultimately the MRI. Disney knew all that, correct?
Correct, Your
All
Honor.
right. So a summary judgment standard is there is no disputed material fact issue, correct? When you look at the
Yes.
record as a whole, the light most favorable to the non-moving party, there's tons of factual disputes in this case, it seems to me. A jury or a fact finder could easily say it was 2014 that really disabled her because you all kept putting her back to work and she worked. She took time off, she vacuuming, back hurt. To me, there are fact issues all over the place. It's a jury question in my mind. What troubles me is the way it's pled, I've said that a few times, but Disney was certainly aware where she was and what she did and what boats she was on, correct?
Certainly, that's true, but it's also, there's a certain level of personal responsibility upon Ms. Grisette. Not only does she have a responsibility after this first injury in December to investigate her claim, which begins the tolling and the accrual of her
First of
cause
all,
of
when
action.
it happened, she felt okay, and went back to work for a couple more weeks before she really went to the doc.
Right, and 2 weeks later, when she goes to
Doc
the
says, well,
doctor.
you know, you maybe need a little rehab or something, but I mean, you kept returning her to work.
Well, she.
I don't think she's, you know, a totally sophisticated person, you know?
I understand, but as you pointed out, Your Honor, she went to the doctor regular. When she had a problem, she complained about it, and she.
Doctor for all kinds of things.
But
Let's retool this just for a second. Let's say instead of pleading in 2011, they had pled in their operative complaint that this happened in 2014, when the luggage fell on her or something like that? Okay. All right, and then that's the problem. Then she went and got her MRI and can't work anymore, et cetera. And they file suit because they said Disney's negligent because of whatever reasons. That's neither here nor there right now. You wouldn't be able to win a statute of limitations defense under those pleadings and those facts. I mean, you could bring up that, well, maybe she had pre-existing problems because in 2011 she had a pop in her back, no different than somebody who is rear-ended in a car accident may have some pre-existing condition. But if it was pled that, and that's kind of what Judge Jacobus is, you know, kind of talking about, that if it was pled that way and it was presented to a trial judge, that trial judge would be hard-pressed, it sounds like in our view, to grant summary judgment on those facts in that pleading, because it would be a fact. Do you agree with that? I know you don't agree with the result that you think I'm leading to with that hypothetical, but do you agree with that would be a problematic to get a summary judgment on a 3-year statute of limitations then?
I think if Ms. Grisette's deposition testimony remains what it is now, which is that this whole thing, this whole lawsuit came about because of the December 2011 accident, then there may be grounds for a summary judgment, although it would be a closer call and there may be an undisputed issue of fact.
No, not the December 11. I thought it was a 2014, the luggage.
He's saying the 2014 bunk falling out of the
If I
bunk
didn't say
bed.
2014, that's what I'm saying.
Right.
It sounds like the 2014 is when she then went back again. And I get she's been going to the doctors, and okay, that's fine. In 2014, she has the luggage event, and I don't mean to be dismissive. I'm just for my sake of how I speak. Or she fell out of the bunk, or something happened, and so then she goes and gets the MRI, and that's when she basically is off of work, and she then sues not long after that, and says, "This is what happened to me, and I'm entitled to some compensatory damage from Disney." Your position of a motion for summary judgment based upon, well, you had a pop in your back in 2011, therefore you barred by statute of limitations, would seem to be problematic if brought or presented to the trial judge at that point if they pled that it was a 2014. Isn't that?
I understand.
It's really okay to answer, yeah, that would be a problem for me, if that really would be a problem. I'm not trying to box you in. We understand your position. I'm just trying to explore other factors here so I have a better understanding when we go back and talk.
Certainly.
Okay.
My response to that is, had Ms. Grazette not testified, had she not said that in December 11 I had this, had she not been urgently medically debarked and incapacitated and taken off work in December 2011, had she not said in August 2012, oh, after I do luggage duty, the pain comes back, I get pain from heavy lifting, that's in the record as well at 407 and 410. Had she not said in August 2013, again before the statute of limitations in this case accrued, that she said, the nature of my work aggravates my back problem. That's on the record at 413. Had she not said all of those things, had she not said, well, the reason why I'm here at this deposition, the reason why this lawsuit is happening is because the luggage fell on me in 2011. If none of that had happened, and the bunk bed incident was the only thing that happened, and that was the first thing that happened, then I agree that there would have been an issue with
So
the
you're
summary
saying
judgment.
then to me that if just as she's working along the way and in 2013 she wants to go to the doctor because her back's hurt, because as we're getting older, things maybe get sore, and we go to the doctor and say, you know, I've been working and I'm sore, that's somehow a triggering cause of action event?
Yes, Your Honor. Mr. Grazette was in her mid-30s when this happened. It's incumbent upon her to say there's something wrong, and she has a duty to investigate. She herself put together, the luggage fell on me, it caused my pain. She herself said, it hurt so bad 2 weeks after that, I couldn't work, so I had to go to the medical center at that point. I'm sorry, it hurt so bad I couldn't move. I had to go to the medical center.
But she said she sat for a while when it happened.
She didn't remember how long she sat for,
But
Your
she
Honor.
sat,
She did, she certainly sat. She stopped work.
went back to work. She didn't go to the doctor then. It was like 2 weeks later.
That's correct. That's correct. But when she did go to the doctor, it hurt so bad that she had to be urgently medically disembarked back to Trinidad, back to get medical care and treatment under Disney's maintenance and cure obligation.
But she wasn't incapacitated until the 2014 incident, correct? So
I
why
would
wouldn't
respect-
why wouldn't her maintenance and cure claim still be viable?
I would respectfully disagree with that statement, Your Honor, because she was incapacitated. She was not fit for duty. She was sent home, and you can see her dates of contract in the record at 483 and 484. She was sent home early from the Wonder. She had only done 2 months. Her testimony was that,
The 2011.
correct.
Yeah, you're right.
She was sent home early from the Wonder.
Well, let me ask then, so if I'm hurt and if I have, my back pops in 2011 and I'm given a week off by my employer, Disney, and I come back to work, you're saying that's when the maintenance and cure cause of action accrued?
If it's your testimony, Your Honor, that your current pain 3 years later all came back and was all caused by the initial luggage incident, yes. Here, it's overwhelming.
So incapacitated is kind of a subjective incapacitated, meaning I had to take 2 days off?
Well, I
Or
don't-
Is there, I guess maybe help me out here.
Sure.
I guess I'm interpreting incapacitated to mean basically, I'm done with working, period. Not that I took 2 or 3 or 4 or a week off because I'm feeling bad as a result of an employment-related incident. I'm now, you're done, you can't work because you're injured. So now I'm incapacitated. Now the maintenance and cure meter starts to run from there until I get to MMI, and if you don't pay me for that, then my cause of action occurs. Isn't that it, or no? I mean, am I reading that wrong?
Respectfully, yes, Your Honor. So incapacitated is I'm injured and
how.
I can never work again. You can become incapacitated and then become cured, reach the point of maximum medical improvement, which is what happened in February 2012, after she had this luggage incident. So she reached the point of maximum cure. However, that does not mean that she cannot later aggravate it.
Was a doctor said she was at MMI in 2012?
I believe that she was. She was certainly fit for duty to return to work.
So
That's
if-
a medical declaration.
But I don't think she ever reached MMI, did she?
Can you have a separate incident or a later incident? Or whether it's, if she fell out of the bunk in 2014, felt immediate pain, has the MRI, and couldn't that be a new incident? Why would that be an aggravation of the
And
old?
I never go back to work?
Yeah.
Sure, let me try to respond to all of these. At present, Ms. Grazette is not at MMI. Her entitlement to MMI is not an issue before the court, and Disney has been providing her with, and does to this day, her maintenance and cure. That is not the issue before the court.
I'm good with that.
With regard to, there can be serial causes of action for maintenance and cure for different things.
Not for Jones Act negligence.
Well, with regard to, this is my injury, I have the same injury, everything goes back to this original back injury in 2011, which is what she very clearly testified to, those claims accrue at the time of the injury, at the time of the event.
Let me ask you then this way here.
Sure.
All right, let's go with you're right. 2011, they file suit in 2015, so the 2011 claim is barred. Is there anything, other than the meters ran again, is there anything that would prevent them from saying, okay, but she got hurt in 2014, i.e. look at my amended complaint, I'm filing a new suit for the new action that accrued in 2014 and to be able to recover damages for that. Now, I understand we're at 2019, they probably didn't do it, so forget that part. We're go back in time, it's now 2016, we're having this oral argument.
Yes, I understand your question, and I believe in response to that Ms. Grazette would not have then been without remedy. She could have brought a suit. She may have been able to bring a later suit.
Is
Correct.
your answer yes to what I just asked you?
But for an aggravation, not for the original injury, which is what we have here. Ms. Grisette's undisputed testimony overwhelmingly establishes that she herself accords all of her back pain back to the original injury. Her testimony from, August 2012, August 2013, she says, well, it's the same pain that I had before in December that I was initially disembarked for. If I may just hit on a couple of points as I'm running out of time with the court's indulgence. I would just like to say that, my esteemed colleague brought up the issue of the complaint being vague, x-rays being fine, those sorts of things. Those things were not raised at the lower court, nor were they raised in the briefing, so I would respectfully aver that they would have been waived.
Record, okay. I mean, what he was saying, that's part of her medical record, that she had an x-ray done whenever it was and didn't show anything.
I may well be mistaken, but I don't recall seeing that in the record in my review of it this weekend, but I defer to the record itself. It was pretty big and pretty voluminous. Again, at the motion for summary judgment hearing, we have the record, we have the transcript. The issue of the amendment to the amendment of the complaint was not raised. That issue has respectfully been waived. It may be, I understand that it may be a harsh result, but it is plaintiff's responsibility to raise that issue at the summary judgment hearing. She cannot now be heard to say, it wasn't fair, I wasn't given an opportunity, when she did have all of the opportunity.
So essentially, your position is while she was still employed by Disney, she needed to have sued Disney sometime before November of 2014 regarding this November of 2011 popping of her neck or back or what have you, to avoid any statute of limitations difficulty.
I think so, and the case law bears that out, Your Honor. The Sweat case is very clear that the fact that Ms. Grisette continued to work despite being, albeit in pain, that does not foreclose the tolling of the statute of limitations. That does not stop her cause of action from accruing that she could continue to work. So the duty remains upon Ms. Grisette to investigate her claim. If I may have just one extra minute to wrap up.
That's fine, I'll give him more time.
Yeah.
But I mean, I guess then that gets back to my question, then, of the maintenance and cure. So if she was able to work, then wouldn't her maintenance and cure not accrue until she was no longer able to work, which was in 2015, and therefore their complaint was timely?
Ms. Grisette was provided maintenance and cure in 2012 when she signed off the ship until such time as she returned to the ship in April 2012. She was provided with maintenance and cure. She, at that time, when she was off the ship, not fit for duty.
But she wasn't at MMI then at that point, right?
If she returned to work, she was considered at maximum medical improvement. But that does not change the fact that, and there is no case law cited in the briefs, that changes the fact that her cause of action accrues on the date of the original
You're saying
injury.
as a matter of law, when she came back to work without a doctor saying you're at MMI, that means she is actually in de facto MMI?
I'm not sure I understand. I'm sorry, Your Honor.
I mean, MMI, I was an insurance defense lawyer, so I understand MMI.
Sure.
So I'm not getting this. So she's hurt, she's off for a period of time, she comes back, no doctor declares her MMI, she soldiers on, and you seem to be telling me that because she came back to work sometime in spring of 2012, that's the end of the maintenance and cure. She got her maintenance, she got her cure, all done. If she wanted to file suit, she had 3 years from that point on to do it, and she didn't do it. Is that?
She had 3 years from that point to file suit for a tort-based aggravation. But you can file suit not only under the Jones Act for a tort-based aggravation, but also under general maritime law, under maintenance and cure alone.
Gotcha.
Insofar, MMI is not a promise that you're perfect, your back's going to be the best forever. Maximum cure, maximum medical improvement is you are as good as we can get you. We have brought you back. This is as good as we can get you. It does not promise that you will not then in the future backslide or re-aggravate your back. But that backsliding, that re-aggravation, it doesn't put upon Disney a lifetime guarantee. It's still, if there is a backslide, if there is a re-aggravation, when she's in the service of the ship, it may trigger a new claim for maintenance and cure. But insofar as it relates back to the original aggravation, that original accident, that aggravation, once it's an aggravation, that relates back to the original 2011 accident, as Ms. Grisette testified to herself.
Let me ask you, when she came back to the ship, then you didn't pay any more, Disney didn't pay maintenance cure to her then because she was working, right?
Correct.
She got then Then when she went off again, you know, off the ship, then you started maintenance and cure again, correct?
I don't have.
I think you
If she
did.
was off the ship because she was medically disembarked, yes, Disney provided her with maintenance and cure. If she was off the ship because it was the regular end of her contract, then she was just on vacation.
That's what I meant, medically, yeah, okay.
Just one more point, if I may. There is a premise in, I think, appellant's argument that a mechanical backache is fundamentally different from a herniation. But if Dr. Mahadeo, the treating physician, he testified at his deposition, that's in the record at 698 and 699, that a mechanical backache, that is a pain from a mechanical instability, which can be due to several things, including a herniation. Notwithstanding, the fact that Ms. Grazette did not realize the gravity or the seriousness of her injury, or that it later got worse, does not change the fact that the case law is very, very clear that for this sort of injury, her cause of action accrued at the time that she knew of the injury and she knew of its cause, which by her own testimony occurred in December of 2011.
Okay, all right. Thank you, counsel.
Thank you, Your Honor.
All righty. Well, you lucked out there, didn't you? You got 4 minutes and 1 second rebuttal instead of 1 second. There you go.
20 years doing it,
What a,
I was having
There
too much
is a
fun
God.
answering your questions. Too much fun answering your questions. On the last point, tailbone pain is not a herniated disc, and it's clear in the letter where Dr. Berrio sent her back. They took the X-ray. There's nothing there. I mean, they're telling you go back. They don't see anything. Okay, that is fundamentally that is wrong. It's not a herniated disc is a very specific injury. It causes radiating pain, and it causes numbness and different depending on how it presents itself. So that is not what happened.
well, help me out
in
about
2011.
maintenance and cure. Obviously, that was a topic of discussion with your opposing counsel here. She seems to say your meter ran back in 2012. We seem to be wondering that, you know, when your lady got hurt with the falling out of the bunk, and then she was incapacitated as of January 2015, that's when your cause of action accrued, and actually, you haven't even got to MMI yet from that, and therefore, you
Right.
certainly shouldn't be precluded from getting maintenance and cure.
Correct.
That's your
And
argument,
that's
right?
Vaughn
You're
says
saying
that. That's a
Vaughn- the US
Supreme Court case.
you and Vaughn.
Incapacitated means you can't go back to work. That's a hard rule. That's what that means. It doesn't mean anything, but you're
It does-
incapacitated.
If I'm understanding Disney's argument, your opposing counsel's argument is, your lady, your client got hurt in 2011. She was, I guess disembarked means something in your all maritime world here. She was disembarked for a while, but she came back and started working again. So that period of time when she was out in 2011 and came back to work, now she's at MMI. Is that how you is that how you interpret what your opposing counsel was saying?
Well, but she is
Not whether you agree with it or not. but-
she's at MMI for purposes of being fit for duty, to undertake her duties.
That's different, you're saying.
Yes, it's different than when you are completely incapacitated.
Incapacitated. I
And they-
can't go back to work, and then that's when.
You cannot, that is it. That's when maintenance and cure. This is medical, this is just what they have to provide as the ship owners, or the captain has to make sure that the crew gets prompt, proper, adequate medical care. That's the terminology. So she's not getting MMI from maintenance and cure. Maintenance and cure is like welfare. It kicks in when it's incapacitated. It's a date certain. You're told you can't go back. That was the 17th of January 2015. And any representation the other way, but otherwise you can just go to the Vaughn case, U.S. Supreme Court, look at that, and that is the rule.
So that's when maintenance and cure kicked in for purposes of our discussion today, and then Disney would be obligated to pay her until she got to MMI for maintenance and cure.
Correct.
And then your position is, there's no doctor that says she's at MMI yet,
That's correct.
and therefore, you trial judge should not have granted summary judgment that precludes that aspect. I mean, I understand your other argument, but that aspect of the claim, that clearly is not even ripe yet
Clearly,
for the
correct, Your
3-year
Honor.
meter to start running.
That is
That's
correct,
your
Your Honor.
argument.
Yes, it is.
All right, I got you.
Okay, and I've got 57 seconds.
You do. And no more.
I know. Thank you very much. I appreciate it.
That's fine. Go
I got carried away. Just to go back to the complaint, and I understand the concern, I'm not going to belabor it. There are two references to the Disney Wonder, but there is nothing that talks about 2011 as far as a date upon which that initial injury was deemed to be the injury upon which she's suing. And I think the court recognizes it's the November 2014 date that prompts them to give her an MRI. They should have given her whatever care she needed, but it was at that time that they did the MRI. And so with that said, I want to thank the court again for your indulgence to allow me to come back up. We ask for a reversal and remand for
All right,
proceedings.
counsel, thank you both. Very
Thank you.
interesting arguments. That now concludes our session. We'll take these cases under advisement, and we'll let you know.
I had a